Hi there. Welcome to the third seminar of the 2024-2025 season of Schwegman, Lundberg, and Woosner's Life Sciences Seminar Series. I am Nicholas Lanzatella, your moderator for the series. During this series, attorneys from the SLW law firm having a background in chemistry or biology will present on various topics in the life sciences in patent law. The seminars will be given on the second Tuesday of each month. If you attend 3 or more of these presentations live, we will send you a free gift if you have a United States mailing address. Slides for today's presentation will be available in the chat, and a link will be emailed to you. As a reminder, nothing in today's presentation should be regarded as legal advice. If you are seeking legal advice, please consult your legal counsel. I am pleased to introduce today's speaker, Ryan Connell, a longtime colleague of mine. Ryan received his bachelor's in science in biochemistry and molecular biology and his Bachelor of Arts in chemistry from the University of Minnesota Duluth and his master's degree in organic chemistry from the University of Minnesota Duluth. He received his JD degree from the University of Minnesota. Ryan is a registered patent attorney practicing intellectual property law with an emphasis on chemical engineering, materials science, biotechnology, and organic chemistry. Ryan also has experience in a variety of mechanical and electromechanical related arts. The title of today's presentation is Inventorship and Assignment, Practical Considerations for Your Patents. This is a bit of a refresher from the presentation Ryan gave last year, which was one of our most popular seminars. So I hope you enjoy Ryan's seminar today. Go ahead, Ryan.
All right, let me get the slides up. Okay, hopefully you can see the slides. I'll put it in presentation mode. All right. First of all, thanks all for making time to come to this webinar today. I'm really excited to speak with you all. And also, being that it's Veterans Day, a happy Veterans Day to anyone who's a veteran on this call or a family member of a veteran. Really appreciate and are very and I have a deep admiration of all that you folks do. So happy Veterans Day. So the title is Inventorship and Assignment, Practical Considerations for Your Patents. So I know, this isn't necessarily an area that's specific to the chemical and bio arts. However, I do find that in the chem and bio fields, there's oftentimes quite a bit of collaboration between entities. Could be, different companies, a company and a university, different research groups within a university. There tends to really kind of be a meeting of minds and people from different areas. And when you start to mix the pot with a lot of people, something like inventorship or who owns a patent or who gets to assign a patent actually comes up quite a bit. And it's just good to be armed with some basic knowledge or considerations on the front end before you get too far down the patent path, just so that you can have your portfolio wrapped up in a good spot. So let's get started. So there's Nicholas and I. That's a picture of me back in the day when I used to have hair. I should probably update that. Just a quick acknowledgement. My colleague, Doug Portnow at the firm, helped me prepare a number of these slides. Back in the day, he's a medical device patent attorney at our firm, and just want to say a quick thank you to him. So the talk today is going to really center around two main themes, inventorship and assignment, and then we'll kind of bring them together to see how they work in conjunction with each other. So starting with inventorship, pretty basic question, why is inventorship relevant? Well, as patent attorneys, sometimes we joke that the Constitution includes what we call our job security clause. The Constitution specifically calls out that to promote progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. In other words, the kind of provisions for patent law are laid out here, or at least the foundation of it. To focus in on the language, if you look at the part highlighted in red, authors and inventors are given the exclusive rights to these. So in the Constitution, it spells out that ownership, or at least initial ownership of a discovery invention, is given to the inventors. Why is assignment relevant? Well, as those of you who have been in this field probably know, oftentimes patents are subject to assignment. So even though the government gives initial rights in a patent to the inventors, inventors are free kind of to do what they want with ownership after the fact, after it's granted. Quite often, inventors, either by their own choice or by obligation, assign their patent rights to other entities in exchange for some form of compensation. At the end of the day, a patent is property and can be owned, exploited, sold, licensed, really, can be used in a form that any other property could be. And so there's oftentimes an interplay between the initial vestment of ownership by terms of being an inventor, and then what's done almost immediately after in terms of assignment. So they really are different concepts. Sometimes they get conflated, but they really are very distinct and different tracks of ownership in a patent. Whoever does ultimately own the patent, whether it's the inventor or whether it's a party who's been assigned the inventor, enjoys all the rights and benefits provided by the patent. So whoever owns it in the end gets to exclude others from making, using, selling, can further assign it, sell it to other people. They can execute licenses for people to use. You have to really, kind of track the ownership of the patent to know who can do whatever they want with the patent ultimately. Again, as I mentioned, with the way the law is set up, the inventor is the initial owner of a patent application. Oftentimes, if the inventor is part of a company or faculty of a university, whatnot, they're oftentimes obligated by terms of an employment agreement to assign their rights in the patent to that employer.
Say, Ryan,
yes.
Your screen has gone black.
Really? All right. Let's see if I can restart the share. Thanks for letting me know.
Some people are saying it was working, so it might have been just one person who had the black screen.
Okay.
So sorry for the interruption.
Oh, no problem. Can you see it now?
Yep, see it fine.
Okay. Yeah. So where was I in this? Probably the last bullet point. So yeah. So once an assignment is executed for an inventor, the inventor doesn't have any ownership right in the patent any longer. Yeah. So moving on. So yeah, so to jump off on that last point, so once an assignment is executed, the patent owner really is kind of out of the picture. Some people wonder, if you're obligated to assign, or if you're an inventor and you have assigned the patent, is there any way that you can challenge a patent's validity in litigation? So can you, say that you were obligated to assign a patent and, you weren't particularly thrilled to do that, and you wanted to kind of get back at whoever you were obligated to assign to and see if you can invalidate the patent. Unfortunately, that doesn't really seem to work. There's a doctrine called a signor. So a signor being like the inventor, whoever assigned the patent to another entity, generally is a stop from challenging the validity of a patent. This Supreme Court case here that I cited limited the estoppel by terms of any express or implied representations about the validity of a patent at the term of assignment, meaning that if you assign the patent application and you expressly stated or implied that the patent was valid, it's hard for you to kind of claw back and say later, I don't think it's valid and I'm going to challenge patent validity. So yeah, it's be a tough road to go if you wanted to try to invalidate a patent that you had already assigned. Something that comes up also kind of after the fact, after some rights of a patent have been transferred, is licensee estoppel. So a license being where you're not transferring ownership of the patent per se, but you're just giving somebody permission to make, use, or sell something covered by the claims in the patent and a promise not to sue for infringement by doing so. There used to be some debate about, somebody might have a license and maybe is sick of paying the fee, the license fee, agreed, and maybe thinks, well, my life would be easier if I just challenged the validity of this patent I'm subject to a license on. It used to be that you couldn't do that. Some jurisdictions still uphold that. This was overruled in the USA, though. Kind of a tough road to hoe to try to invalidate a patent if you're a licensee, but an option nonetheless. So that's just kind of a quick overview of kind of some of the initial considerations of where patents initially vest in terms of ownership and what you can do with your ownership right in terms of assigning it, licensing it, and then kind of what a few of the rights are after the fact. But let's dig into inventorship a little bit, because who an inventor actually is legally is really quite important. I'll say that in patent law we typically don't get a John Grisham novel written about patent lawyers or trendy TV shows about patent law. It's pretty clean area. But if there was to be an area where there would be some drama, inventorship is it, because who an inventor is actually a pretty stringent legal standard. And for the purposes of patent law in the United States, an inventor is considered to be a person who contributed to the conception of the claimed invention. So conception's kind of a loaded legal word. It's defined as the formation in the mind of an inventor of a definite and permanent idea of the complete and operative invention as it is thereafter to be applied in practice. In other words, to be an inventor, you have to have been the person who conceived of the invention in such a way that was clear enough to allow one of skill in the art to implement the invention in a practical form. In other words, I kind of think of it as you have to have such a concrete idea of what your invention is that you can explain to somebody how to make and use it, and give them enough and have enough detail at your command that it could be done, and not just kind of wishy-washy, not talking and speaking in platitudes, but with some detail, and really have possession of it. In other words, that's called having it informed that it can be reduced to practice. That doesn't mean that you actually have to make it. Being able to actually make the invention is super and is a concrete way of showing conception. But there's also constructive reduction to practice, meaning kind of on paper or in words, being able to describe your invention clear enough. Either one works. But really, to be an inventor, you got to be the person who has that clear conception of the idea. As far as what that is tested against, inventorship is determined based on the claims. So you're looking to determine who an inventor is. You look at the claims, and then claim by claim, ask yourself who is responsible for the conception of the subject matter in this claim. It doesn't matter what's in the detailed description. It doesn't matter what's in an example, summary, anything. It's just in the claims. That's can be different in other jurisdictions, but in the US, claims only. Where it gets tricky is that, it's not uncommon for an invention or the inventive activities to include multiple people. And not every person necessarily can be said to have conceived of the idea or feature that finds itself in a claim. Sometimes people are helping, working at somebody's direction, executing protocols given to them, or testing an invention, or just various things. These people, if they're just acting under the direction of somebody else and not kind of independently conceiving of these ideas, are not inventors. And sometimes where this gets confused, and this is common with academia, is that the standard of authorship, like for an academic journal, is comparatively quite permissive, right? I mean, you can have undergrad students or some early graduate students, postdocs even, who are acting at the direction of a principal investigator, who get listed as an author, and that's completely fine. And then, but you have to understand that these rules don't port over, or these conventions don't port over to inventorship, where the standard is more exacting. It really needs to be correct too. We'll get into some of the consequences of getting inventorship wrong here momentarily. But just to kind of highlight it, if somebody wasn't listed as an inventor, they can get themselves on the application and claw back some rights. If missing inventorship, not adding somebody, or adding somebody who shouldn't have been added in some circumstances, at the most extreme, can lead to unenforceability or invalidation of the patent at the extreme. So it's really quite important to discern, particularly when you have a big group of people working on something, as chemical and biotech inventions can, to make sure you discern who is an inventor and who isn't. I've listed out some pretty basic examples here, that if you're an investigator and you come up with a new molecule, conceive the molecule, write it down, generate a synthetic scheme, and then give it to a lab worker to synthesize it. And the lab worker, just kind of follows the protocol you laid out. The lab worker, would be a contributor, certainly, but not an inventor. Now, if a lab worker modifies the molecule, like makes a derivative, adds a couple functional groups, something, it stirs ideas, they push it to a new invention, that might be a different story, quite fact dependent. So patent applications can have as many inventors as is needed. Again, it just depends on who could be said to contribute to the conception of a claim. Some interesting things are that to be an inventor, you don't have to have equal contribution to the subject matter in the claims. It doesn't matter if one person did 90%, another person did 5%, and then another person did 5%. They would all be inventors for the purposes of patent law. An inventor really only needs to contribute to the subject matter of one claim of the total invention. Like I said, don't confuse the journal article authorship rules or standards with patent inventorship. Patent inventorship is just far more stringent. This really is a point where it can get contentious if you're dealing with this, where people, justifiably so, they worked on a project, they did probably, some hard work to get there, but yet they don't get to be listed as an inventor. And, this is where preparation really helps, so that you're not like on the eve of filing and then you get an inventorship dispute. Having a conversation with people early on, like when the first draft of claims is generated, and discerning who's an inventor and who isn't. If there's a larger group, can really help on the forefront. Especially, it's one thing if it's all people within the same company. It can be, even if a little contentious, it can be reasonable to get everybody on board with who's an inventor, who's not. But where it can get really sticky and where front end preparation really helps is if there's a joint venture, different entities working together. Um, and especially if one entity maybe isn't going to make the cut for inventorship with any of their people, talking about this beforehand and getting it settled is key to making your life much easier. And also, one of the reasons too that people tend to really want to get listed as an inventor beyond, just ownership rights and stuff. If they're working at a company, having your name on a patent is a way to get some recognition. You're contributing to the company by being a named inventor on a patent. That's why sometimes people really fight to get themselves listed as an inventor. Some companies I've worked with have a pretty good solution for this, where they have something built into their corporate scheme where people who contributed to an invention but couldn't be made as an inventor nonetheless get some official recognition or something passed up through their management chain just to designate that they were helpful in this. And that seems to kind of smooth things over to get people, the recognition that they deserve. A few kind of notes on who can be an inventor again. A company in the U.S., the company can't be considered as an inventor. Again, going back to that provision in the Constitution, it's ownership, inventorship is vested in people, not companies. AI is not considered an inventor. I mean, I know the AI world is ever changing and dynamic, but for now, no. Whoever an inventor is, that's a question of federal law, not state law. It can't be contracted in state with state law or anything like that. It's strictly controlled by federal law and can be resolved in the PTO or in federal court.
Ryan,
again,
before you leave that slide, we have a question
sure.
regarding AI. The question is, could there be any human inventorship issues with de novo protein structure of which was elucidated by the AI-based program? And for example, in 2024, Nobel laureate in chemistry David Baker's lab, for an example. Do you have any thoughts on that?
Yeah, sorry to kind of give a cop out, but yeah, I'd have to see how it gets handled. I mean, this is kind of the new frontier, right? Yeah, I'm not entirely sure how that's going
Sure,
to play
that's
out. Now,
totally
you
fair.
could say, yeah, I could see an argument that you were directing your AI to come up with these things, and you recognized it, and then you maybe took it a step further than what the AI said, and kind of a use for it, or how it fits into a grander scheme. Maybe you were directing. I'm not. It's exciting to try to figure out, but we'll see how these things go in the future.
So for the audience, if you're interested in questions like that, I encourage you to go and look at the recording of the first webinar I gave, which described issues about AI and inventorship. As Ryan said, we definitely know that AI cannot be an inventor, but there has to be a human inventor in the equation. So really the question might sort of be, is there an issue with human inventors having done enough to be inventors if they're using AI to elucidate protein structures? And that can be determined by looking at the kind of prompts that the inventor passed to the AI. There's another developing area that there hasn't been a lot of case law on yet, but some of the PTO guidelines suggest that the makers or trainers of an AI might be considered inventors in certain circumstances. And I mean, it'll be interesting to see how that area of the law develops. But that's what I have to say about that.
Yeah, it's definitely the new frontier. right? It's amazing how we came from, was it a few years ago? There was that question about, is it a monkey took a picture or something? There was a question if they could have a copyright, and now a few years now we're dealing with this. So we'll see where it goes.
Well, there's one more question, Ryan. A question is, does a law firm have a conflict of interest with a client when a patent attorney at the law firm who drafts and files the patent application is a co-inventor of the invention of the patent application, where the co-inventors of the invention are the client's employees? If so, how to avoid this problem? Any thoughts on that, Ryan?
Yeah, I've got a slide on that coming up. Um,
Okay.
yeah, no, that's a very very good question. So yeah, we'll put a pin in that, and we'll yeah get to it. Um, yeah, artificial intelligence and inventorship. Yeah, just like we were discussing. Yeah, it's inconsistent out there. One country that awarded uh, that 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 awarded inventorship based on AI is South Africa, but and take that with a grain of salt because South African patents by their scheme are not examined. They're registered and presumed valid with just minimal examination unless and until it's challenged for validity. So I wouldn't just based on that alone, I wouldn't rest on AI being an inventor. Yeah, it's just to be determined. At least in the EPO, AI can't be an inventor. Again, in the US, it's, trending towards must be a human. Um, it just, it's so it can vary across the world and is probably going to vary for a while until it's ultimately settled. But the takeaway is just, look at whatever jurisdiction you're in and see what their rules are. So to get that question, patent attorney and inventor, um, you know, it can happen. I've had a few cases where I've seen a patent attorney find their way onto being an to inventorship. Um, I've seen it more commonly with in-house patent attorneys finding their way to inventorship. Occasionally, I've seen outside counsel. Um, I've I've never found my way to being an inventor, and I try very hard not to be. It's a great way to get yourself into a sticky situation, like that question was getting at. Where yeah, I mean, if you're the attorney, yeah, it could, imagine if you're a patent attorney and you find yourself as an inventor, the other inventors are obligated to assign to the company, your client, you're not. Um, that could, put you in a pretty sticky situation in terms of, what you're obligated to do personally versus what you might be obligated to do to a client. It's just one of those things where it can be a mess. And I try I have no intention of ever being listed as an inventor on any work that my client does. I just really don't want to be in that position at all. And there's kind of a question of, as an attorney, are you really kind of coming up with these ideas? I mean, it's the client's invention, the client's um, idea that's coming to you. Are you really making an invention, or are you just expanding on what they're inventing and just putting it into the proper language for patents being in the claims that you put into the claims. There was a case, Solomon versus Kimberly Clark. Um, this wasn't necessarily the holding, might have been more dicta, but they found on the facts of that, they stated that patent attorney isn't an inventor in a patent application, that they're prosecuting because the patent attorney's role is to define the invention and not really be an inventor or conceive of claim subject matter. Um, it's just, yeah, something to avoid, because as that question was getting at, it can put you in a sticky situation for sure. And it also just, as far as, client relations, it's kind of uh, a good way to make an uncomfortable dynamic between you and your client, to try to characterize yourself as an inventor on something that they came up with. So I would, yeah, advise against trying to get yourself listed. One thing about inventorship too is it can change during the course of prosecution. So again, inventorship is determined based on the claims. So just because, so as you know, during prosecution, the claims change, right? You might file with, say, claims 1 through 20. You went through all your determinations, found inventors A, B, and C are appropriate to list. And then during prosecution, amendments can be made to the claim to overcome rejection. So maybe you pull some subject matter from the specification or an example, and then that subject matter finds its way into a claim, and turns out, oh, who came up with that was person D. So if that finds its way into a claim, then you have to amend or change your inventorship to include that person. Likewise, if you had to, cancel or remove some subject matter, and it turns out that that was inventor C's, well, inventor C isn't an inventor anymore if that was the only thing that gave rise to inventorship for them. So you really have to try to keep an eye on that as best you can. In an ideal world, when you're going through the drafting process, you might keep a chart on the side to keep in the file, attributing each inventor to each feature, so you can keep track of these things as the case evolves. I realize that's pretty idealistic, but that is best practice to make sure that you keep inventorship correct from the time of filing to ultimate issuance. This is another area that can be emotionally loaded. The order of inventors. It doesn't matter legally how anyone's listed. It gives no importance at all. Typically, whoever's the first listed inventor is the one who gets their name published on the header of the patent application. So sometimes people like to, whoever contributed the most, so to speak, tends to want to be the first inventor, so their name is up there, or maybe the more senior person likes to have their name up there. It's just something that, I would ask about it, if there's any preference to naming order at the front end, just to avoid it. Once the application's published, whoever's listed as the first inventor gets their name up there, and it's pretty static at that point. And it's happened before where a client wants to change that, and it's kind of too late. If you anticipate anything where an inventor might want their name listed first, I would just ask about it at the front end and get that over with. Some companies I've seen, to sidestep this issue, just have a strict alphabetical order listing for these things. So it's company policy, so they don't have to deal with this. Just something to keep in mind. It's happened more times than you might think, where this becomes an ego issue down the road. But other than that, there's no legal significance of who's listed in what order. Inventorship, though, is completely correctable so long as there's not deceptive intent. You can correct inventorship through procedure laid out in the regs, or through a lawsuit under the statutes. It's really no big deal. You just get an order like this, and it can fix inventorship by adding or removing as needed. Yeah, so moving on to assignment then, now that we've got inventorship settled. Assignment has to do with ownership. As I've said a few times, the inventors are the first owners of the patent application. More often than not, whoever the inventor is at a company is obligated to assign their rights in any inventions to the company. Once that assignment is done, the company, not the inventor, is the owner of the patent. So the inventor is, if it's just a pure assignment, there's no more ownership by the inventor. Their names are still on there. They're still, forever listed as the inventors of the patent, but they don't have any ownership. There's a couple of ways, kind of theories underlying this that, so if there isn't, just a straight up assignment or an obligation to assign laid out in an employment agreement, and if you are starting a company or have a company and you have people inventing in your company and you don't have an obligation to assign in your employment agreement, that's really will make your life much easier if you get that set up on the front end. It can happen. I've had, a couple of startup companies, like a 3-person startup. And, one of the first things when they come to me for a patent application that I like to ask is, do you have any assignment obligations set up? It's very important to get that set at the front end, while things are good. Otherwise, you could have a situation in your, say a 3-person startup where things go sour, and then maybe, say all 3 of the people are inventors. There's no control by the company over what's done with everybody's individual rights as inventors, and can get really messy. If you had a assignment agreement set up or an obligation to assign, then that IP asset would be owned by the company, not by the individuals. So, if you are an employee at a company, your odds are, I mean, if you're wondering if you have an obligation to assign your IP rights, I mean, odds are you probably do. I mean, there's some, theories that say that if you're hired to invent and you use your company's resources to invent, it's likely that your company can get an obligation to assign out of you, or at least have what's kind of referred to as shop rights, meaning a license to practice an invention that was conceived at least with some company resources. In some theories, corporate officers might have a fiduciary duty to assign inventions that they're inventors on to their employers. But yeah, at the end of the day, it's really about checking your employment or your consulting agreements too. That's where this can come in. If you were hired as a third-party consultant and you did some inventive activities, there's a question of who owns the patent afterward. I mean, if there's no agreement or obligation to assign in your consulting agreement, you might own an interest in that patent free and clear. But most of the time, if you're signing a consulting agreement, there's some distribution of IP. If you are hiring consultants and don't have something about IP ownership in there, good time to revisit your agreement. The reason this is important is that an inventor, well, if you have multiple inventors and, all things being equal, those inventors are considered to be joint owners of the patent, having an undivided right to make, use, and offer to sell the invention without the consent of the other joint owners. So if you have a patent application, 2 inventors, and no assignment, inventors A and B can each do as they please with that patent. They can sell their rights in the patent to somebody else. So say inventor A sells or assigns their rights in the patents to, company C, then inventor B and is a joint owner with a different company, then they can each license to other people. So if, say, inventor A licenses their right to the patents to company C, but inventor B doesn't like company C and wanted to sue them for infringement, well, inventor B is out of luck because the other inventors free to license to that company. So you can kind of see how it can kind of be a mess if you just have two inventors, each with the right to do with what they please with the invention, as opposed to if they assign it up to an entity. It really can be a mess. I mean, it's at first, with these companies, everything is going well, everyone's getting along, but over time, not always, but sometimes things can really change, and that's a time where you kind of would prefer to have the patent assigned to a different company or to an entity as opposed to held by individuals. Just as an example here of how things can get, if inventorship and assignment aren't buttoned up. Here, Ethicon versus U.S. Surgical Corp. Ethicon sued U.S. Surgical for infringement. It turns out that there was a inventor who was omitted, wasn't listed as an inventor on the patent. That omitted inventor got wind of this and contacted U.S. Surgical, and then licensed their rights in the patent to U.S. Surgical. So with that, you can imagine then U.S. Surgical isn't an infringer anymore, right? Because an inventor licensed their rights in the patent to them. So of course this was challenged, the inventorship, and the court found that the omitted inventor, was indeed an inventor. So with that, the inventor exercised their rights to license, and then with that, U.S. Surgical was no longer an infringer, and the case was dismissed. So this case, highlights two points. One, get your inventorship right on the front end, and then B, make sure that you have assignment buttoned up as well, so that you can avoid something like this, with similar effect, even if the facts of your circumstances might differ slightly from this.
Brian, a couple questions here from the audience. Here's the first one. If an inventor is erroneously named on a provisional application and the plan is to remove that inventor at the time of conversion, is the best approach to still obtain an assignment from that erroneous inventor, or can that assignment be skipped?
Good question. It can't hurt. I mean, again, going back to, what I said before about, the inventorship can change, right? I mean, maybe, the erroneous inventor, what if the claims change during prosecution, and all of a sudden some subject matter comes in and brings that inventor back into the fold? At least you would have, some assignment going way back when to, I mean, I would do another assignment at the time, but, at least, belts and suspenders. Yeah.
That's a complicated question. I would probably play it safe rather than be sorry later. I would probably take your same approach there. Here's another question. If an inventor uses an employer's resources to invent, then does the employer own the invention or just have a limited unassignable right to use the invention itself?
Yeah, so that's kind of going to that shop rights that I use. So, highly fact dependent, right? I mean, there might be some instances where, if it's important enough and you fought for it, that maybe a obligation to assign could be, defined from the specific facts. That shop rights thing is certainly a real consideration as well. It just it's highly fact dependent. What resources were used? Were they really company resources? It can get kind of messy, but I would just say that ultimately it could result in an obligation to assign shop right or shop right. Certainly, those facts like that give rise to those possibilities.
Good answer. One more question, going back to joint ventures. So in a joint venture context, does only one applicant prosecute the patent application where all the other parties in the joint venture are listed as assignees, or are there multiple applicants as well?
That is often controlled by whatever the joint venture agreement dictates. There's not, like one scheme that's mandatory here. I've had joint venture cases that I've prosecuted where by the terms of the agreement, just one party is responsible for it all. The other party might review, but one party has the final say on all things. Other agreements are more collaborative. It just really depends on what's spelled out in that joint agreement. Just for ease, I find it's easier to have an agreement where it's just one party who makes the final call, but it's kind of all suited to what works for you and how much trust and collaboration you have with your joint partner.
I agree. I've had various experiences with that too. There is one more question that just came in, and it is, are all assignments 100% or can inventors have partial rights?
Yeah, that's a good question. It's assignments when it comes down to it are a contract, and you have quite a bit of latitude in terms of how you want to contract it. I will say, in my experience, I've really only done assignments where it's been 100%. But depending on how you want to draft up the assignments, as long as it meets the minimums of a contract, offer, acceptance, consideration, you have freedom to contract.
Good answers, Ryan. That's all for now.
Cool. I haven't had to say offer, acceptance, consideration since studying for the bar. That was kind of a reflex, I guess. I got it still. So just a real quick side note here. That's kind of interesting to me, at least. I wrote an article, I guess 10 years ago now, about IP in estate law, kind of what to do with any IP in an estate. So if you'll indulge me here, just kind of a thought experiment of community property and ownership. So certain states, right, like California, Washington, where I'm located now, and I guess my native state, Wisconsin, are community property states. So, would property acquired during a marriage that's community property, would that include a patent right? I mean, it's property, right? So could that be put in the pot? Could that be something that ownership could be split in a divorce or something like that? Just kind of an interesting thought experiment, maybe to me at least. Where there was a case in California where somebody tried to go down that road, but unfortunately for getting an answer, but maybe not unfortunate for the parties, the divorce decree agreed that there weren't community assets in the pot, so the court didn't rule on it. But kind of an interesting question, nevertheless, for community property states. So this is kind of going to that earlier question. So yeah, assignment is just a matter of contract law. So you can, as long as you meet the big three requirements for a contract, you've got quite a bit of latitude in terms of how you structure your assignment agreements. Consideration. There's got to be something given to an employee or to the assignor to make the deal. I've seen like as small as $1 listed in the contract. Some companies are more generous. Like there's like a bigger monetary amount. It just all varies. Yeah, complete freedom to contract on the assignments. An assignment itself, this is just kind of an example, one that's published. Yeah, they're pretty standard. Like I said, I haven't done any exotic assignments. Not that we couldn't, but the ones I've typically done, list out the inventors, list out the application, has the magic words about good and valuable consideration, agreement to transfer, all that good stuff. These forms are not terribly exotic and can be created by your attorney to make sure that assignment occurs. You have to get it notarized, have a witness, and then of course have your assignor and assignees sign off on it. One thing that is important, though, once you have your assignment document signed, is to make sure that you get it recorded, just like you would if you were to buy and sell real estate and go to the county office to have the deed registered. If you ever do an assignment of a patent, you have to make sure you go to the patent office and get it recorded. And it's super easy to do. Your attorney can certainly handle this. And then once you get it recorded, you get a confirmation document like this. Important to do, because recording an assignment provides notice against people who want to assert an ownership interest in a patent later. Say, make sure you record your assignments timely. If it's not recorded, for all intents and purposes, when it comes to an action against it, it doesn't exist for all as far as the for intents and purposes. So just don't delay. Record your assignment as soon as possible. As far as timing to do an assignment, I just would suggest assigning it as soon as possible. Like, some clients will, when they have the inventors sign off on the patent, they'll include that assignment along with it. It's just inventors can change jobs. It's hard. It might be harder to find them once they're out of the company. If they leave the company, they might not feel inclined to help the company. So it's just best to get things signed quick while feelings are good. If a company has an obligation to assign with somebody and they don't, they refuse to sign or can't be found, there are mechanisms to get an assignment executed and carried out. It's cumbersome, and it's just not as easy as just getting them to sign. So try to do it as soon as you can. Provisional applications, kind of related to that earlier question. Do assignments in provisionals. Often the assignment document will say, that I assign rights in this patent and essentially any progeny claiming priority to it. I would just assign as soon as possible and just keep that chain of assignment intact.
Ryan, a couple questions here from the chat. A few folks asking about this. One person asked, what does the law require in terms of notarization and/or signing in the presence of one or more witnesses? And another similar question or comment from another attendee is, I'm not aware of any statute or regulation that mandates that assignments need to be notarized. Have I been misled?
I think it can't hurt. I'll have to take a look. I've seen them as notarized before. And
I think it depends on the country.
Yeah, that's true too.
Some countries outside the U.S. do require it, and I know that we routinely seek, wet signatures, for example, and notarization. And some institutions that know they'll be pursuing patent protection outside the United States will, as a matter of course, get notarization or that hard signature in ink.
That's true. And especially if the provisional, you never know where it's going to, well, I mean, you might know, but it can matriculate into a ton of different countries, and each country has their own unique regulations for the patents. So yeah, it's just good to be buttoned up early to, put yourself in the best position to pursue these globally.
Another question. Lots of questions today, Ryan. You had a slide earlier entitled "Other Assignment Issues." There's a request from the audience to talk about language in the assignment that "quote unquote" carries through from provisional to PCT to U.S. or foreign applications versus getting new assignments. So I guess the question is, do you need to get a new assignment for each application as the family moves forward in time, or not?
I tend to. It just to again, belts and suspenders. It just, the having it applied to the progeny is great and works, but why not head off an issue before it can become one. And also, sometimes between the provisional and the PCT or national stage, there might be added subject matter. Why not just cover all your bases and make sure everything is assigned, is kind of my take on it. I think, yeah, just heading off potential issues before they can become one that you may ultimately prevail on, but save yourself the time and trouble.
We have an interesting comment I just wanted to share. The comment is the whole wet signature versus digital signature issue could be its own webinar.
Yes,
I
it
agree
could.
on that, and there's an idea for a future webinar. One last question: is there an issue with validity of an inventor's assignments that are conducted in foreign countries? Could an assignment being executed in a foreign country cause gives the ability to challenge that assignment in the U.S.? That's sort of an interesting question.
Um, I haven't seen it.
I haven't seen it either.
Yeah.
I mean, it's the
Yeah.
same rules.
Yeah.
If there's witnesses, if it's executed properly,
Yeah.
I've never seen a problem with
Yeah.
that. Yet another question they're pouring in. Can you elaborate on your opinions if a former employee inventor won't assign or cannot be found after they left the company, won't assign to their employer, and the employment contract is vague or silent regarding an obligation to assign to the company?
Yeah. That's, you'd have to go through the steps to get a to get it characterized as assigned. It's there's processes for it. It certainly can be done. It's I've done it. It's there, and it's just highly fact dependent. If the agreement says that that they had an obligation to assign rights and patents during the course of their employment, you just use that. If it's vague, you might have to go through steps to get it interpreted the way you want. It's just there's procedures for it. It's just, it can be a little time consuming under some circumstances, but yeah, it's all highly fact dependent.
Yeah, my quick 2 cents on that is that's a situation that should be, avoided at all costs. And it's one of our jobs as patent attorneys is to make sure our clients do have employment agreements in place so they don't run into that situation.
Yeah, and let's see, we're coming up on the hour, so I'm gonna kind of hit the turbo mode here. Just assignments can get corrected. It's not ideal, but sometimes there can be typos in the assignment. A common culprit is the entity identifier, be it incorporated, LLC, and the like. Sometimes incorporated is all caps, sometimes it's not. So no big deal. Well, I mean, you'd ideally not do that, but if it does happen, you can just do corrective assignments. So don't sweat it. If you do find a typo, though, in the assignment, make sure you resolve it as quickly as possible. You don't want to be, on the verge of, say, having your company acquired or something like that, and then in the IP due diligence, something little like that comes up, and you have to sort it out, and it delays things. So yeah, if you see something, get it corrected as soon as possible. This kind of gets at some of the that last question we had. Make sure that you have an employment agreement with everybody that works in your company. Get it set up as soon as possible. If the inventor is unwilling to sign, can't be found, died, you can record the employment or consulting agreement as a proof of assignment to get that to get the assignment carried out that you want. I think we touched on this earlier, but yeah, just sometimes people conflate assignment versus licensing. just keep in mind, assignment means that you own some right in the patent. It's yours, you own it. Licensing is just letting somebody use your patent. You're not giving ownership, you're just letting them use it and promising not to sue for infringement under that patent. Let's see, assignment. Yeah, like I said before, you can slice up, freedom to contract. You can do creative assignment rights, or kind of which rights you do want to give. Again, I've typically only done full ownership, but that doesn't mean that's all that can be done. Also with the license, if you get into that, this also could be its own webinar, is licensing, but you can license somebody full rights to use your patent. You can limit them to a certain field or a certain geographical territory. You can limit it for a time period, like you can use this for 5 years only. It's just some pretty creative stuff you can do with your patent rights. Handy tools, just, yeah, if you're, the stuff with inventorship, assignment, tracking it can get pretty wild pretty quick. If you have an internal docketing system, it may have helpful tools to help you track this. If not, you can get it set up, or you can have your attorneys kind of track this and advise on this stuff throughout. If you are looking into somebody else's property, the PTO website, Patent Center, spells out all published data, right? So you can track who the inventors are. You can make sure that the chain of title from inventor, assignment, all that stuff is where you want it to be. You can see if a company is assigned to another company. You can really track all these things through publicly available tools. Yeah. Happy to answer any questions remaining. I've got a couple minutes, and yeah, thanks all for listening and for the participation with questions. It was really enjoyable.
Ryan, excellent job. I thought your presentation was really interesting, and it was very clear, all the points you made, and you did a great job fielding the wide variety of questions from our kind and very involved audience. So thank you, audience, so much for your interest in Ryan's topic and for asking all the questions. Thank you for attending the presentation today. If you do have any additional questions, please feel free to email Ryan. Slides for today's presentations are available in the chat, and a link will be emailed to you. There's a request here in the comments. It would be great if SLW would host an assignment webinar for paralegals and legal assistants, how to do them and details to check, Ryan. So there's a lot of interest in your topic. The seminars are held, let's see here. There is one more question. Do you have best practices for using 3.73 documents during patent prosecution? Now, I don't offhand know what those are. Do you know what those are, Ryan?
No, I don't. Nothing kind of comes to mind on that immediately. But if you email me that question, whoever asked it, my email address should be available here. I think it's just rconnell@slwip.com. Send me a note and I can do some digging.
Okay, great. Slides will also be emailed to you if you don't see them in the chat. So don't worry if you don't have those slides yet. You will get an email. So I hope that you tune in to the next seminar, the second Tuesday next month. Thank you very much for your attention today.
Thanks, everyone.